conference, and I've built that so that like-minded scholars come together. But that's something that exists outside of the academy.
Okay, good afternoon. My name is Asla Bali. I teach here at UCLA School of Law, and I'm a core member of the Critical Race Studies program. And I am delighted to welcome you to our afternoon session, which is on global engagements with whiteness. For those of you who have taken a look at your program, you might see that under that title, you have a description of what we're going to be discussing that's a little bit dissonant with our global theme. So I'm just going to say a little bit right now about what we're actually going to be talking about, which will not be so much local governance as global governance. So the problem of race and racial inequality transcends the United States. Across the globe, different nations have promulgated different legal regimes to combat the racial vulnerabilities of non-white populations. As in the United States, these efforts have met with various levels of success, but none has eliminated the operation of whiteness as a baseline that embeds racial hierarchy. In this respect, it is fair to say that the normalization and privileging of whiteness is a global phenomenon with which scholars and practitioners have had to contend. At the same time, there are distinctions between how whiteness is constituted in and across different contexts and how it intersects with broader contestations concerning human rights, indigeneity, national formations, and conflict. The nature of these distinctions in how whiteness is constituted and their intersections with a host of local political struggles is the subject of this panel. The panel will engage with these questions across nearly every region of the world, beginning with the valorization of whiteness amidst the racial mixture public rhetoric that has become dominant in parts of Latin America, turning to parallels between American settler colonialism and Israeli settler colonialism in the production and entrenchment of strands of racism, privileging forms of whiteness, to the deployment of the whiteness as property model developed in Cheryl Harris's work in the context of Australian Indigenous peoples movements, to the value of whiteness as property as a theoretical framework for unpacking racialized dynamics in South Africa and Zimbabwe, to an assessment of the role of critical race feminist studies in the South African struggle more broadly. Spanning then Latin America, the Middle East, the Asia-Pacific region, and the Southern African context, we could not hope for a richer and more truly international engagement with the significance of Cheryl Harris's work uncovering the normalization and privileging of whiteness. We are incredibly fortunate to be joined by a very distinguished panel this afternoon to lead us across these global landscapes. You all have the full biographies, of course, of our panelists before you, but I would be remiss if I did not mention some of the highlights of their work and their accomplishments in introducing this panel, in part because I hope many of these names are absolutely household names, even to those of you who don't focus necessarily in your own work on international scholarship and international practice. But for those of you who may not know exactly how these dynamics unfold, I think it is instructive to give you also a little bit of a guided tour through this amazing panel that we have assembled today. I'm going to introduce our speakers in the order in which they will speak, and once I've concluded these introductions, each will have 15 minutes for their presentation, followed by what I hope will be an equally lively set of engagements with you, our audience, and I especially invite your reflections on how you can situate the work and scholarship, activism, and political struggles you're most engaged with these international stories. These may not be the first sets of engagements that you think of when you think of this paradigm, this framework, and this area of study, but these are incredibly important connections that I hope we can really tease out in our discussion. So with that, the first of our speakers seated directly to my right, and they're seated in order, is Tanya Hernandez. And she is a professor of law at Fordham University School of Law, where she teaches comparative employment discrimination, critical race theory, the science of implicit bias in the law, and trusts and wills. She received her AB from Brown and her JD from Yale. She was awarded a faculty fellowship at the Korematsu Center for Law and Equality. She has previously served as a law and public affairs fellow at Princeton, a faculty fellow at the Institute for Research on Women at Rutgers, and is an independent scholar in residence at the Schomburg Center for Research in Black Culture. Hispanic Business Magazine selected her as one of the 100 most influential Hispanics of 2007, and she serves on the editorial board of the Latino Studies Journal. She'll be followed by Professor George Basharat, who is professor of law at the UC Hastings School of Law. Prior to joining Hastings, he served as a trial lawyer for the Office of the Public Defender in San Francisco. Professor Basharat studied law, anthropology, and Middle East studies at Harvard, and is the author of the book Palestinian Lawyers and Israeli Rule, Law and Disorder in the West Bank, which examines the role of Palestinian lawyers working under Israeli military occupation in the West Bank. Other recent publications include his articles Stumbling Forward in Syria from this year, Anthropology and Law as Two Sibling Rivals from 2013, and Violence's Law, Israel's Campaign to Transform International Legal Norms. He writes frequently on law and politics in the Middle East, both for academic audiences and for the major media sources in the US and abroad. Professor Basharat will be followed by Eileen Morton Robinson, who is Professor of Indigenous Studies at Queensland University of Technology and is also the Director of the National Indigenous Research and Knowledges Network, where she teaches the Indigenous Postgraduate Research Capacity Building Program. She was also the founding president of the Australian Critical Race and Whiteness Studies Association. As one of Australia's leading Indigenous academics, Professor Morton Robinson receives numerous invitations to give presentations nationally and internationally, and has served as an invited lecturer at the University of Washington, Oberlin, University of London, University of Geneva, University of Illinois, Wesleyan, University of Hawaii, University of Michigan, and the University of Alberta, in addition to her previous lectures here at UCLA, and I'm happy to say this is not the first time I've had the pleasure of sharing a podium with her. She will be followed directly by Tendai Achiume, who is Assistant Professor of Law here at UCLA. Her research and teaching interests lie in international human rights law, international refugee law, international criminal justice, and property. She earned both her BA and JD from Yale, while also completing a graduate certificate in development studies from Yale. While at Yale Law, she was a recipient of the Fox International Fellowship and the Howard Holtzman Fellowship in International Arbitration and Dispute Resolution. And after graduation, she clerked on the Constitutional Court of South Africa, followed by holding the Bernstein International Human Rights Fellowship to work for Lawyers for Human Rights in Johannesburg. Professor Achiume has also taught on the faculty of the International Human Rights Exchange Program based at the University of Witwatersrand, I apologize for that, Witwatersrand, and served as a litigation associate at the New York office of Sullivan and Cromwell. Her most recent publication is Beyond Prejudice, Structural Xenophobic Discrimination Against Refugees. Finally, she is followed by Justice Albie Sachs, who is currently visiting professor of law and Gruber Global Constitutionalism Fellow at Yale Law School. He has a long history in human rights activism in South Africa and was appointed by President Nelson Mandela to serve on the country's constitutional court from 1994 to 2009. While on the court, Justice Sachs received international attention as the author of the court's path-breaking holding in a case in which the court overturned South Africa's statute defining marriage to be between one man and one woman as a violation of equal protection and the constitutional mandate against discrimination on the basis of sexual orientation. He holds a law degree from the University of Cape Town and a PhD from Sussex University, and is the recipient of countless awards, including the Alan Paton Award for his book, Soft Vengeance of a Freedom Fighter. In addition, of course, to 14 honorary degrees that he's been awarded across 4 continents. Since retiring from the Constitutional Court, he continues to write, speak, and teach around the world, sharing the South African experience of post-apartheid transition, something that he will undoubtedly touch upon in his presentation to us today. And so with that, I turn to Professor Hernandez.
Sorry. Thank you very much. It's a great pleasure to be here. I wanted to share with you a brief little anecdote, and maybe it's good that Cheryl's not in the room because it's a little bit embarrassing. Oh, she is. Oops. Oh, well. You switched seats on me. Okay, well, I don't think I've ever shared this with you because it was a little embarrassing, but when I first started to try to write my first article as a law professor, I was working on the multiracial category movement, etc. And your article, right, WASP, was very formative. And so I set about writing the very first draft, and my mentor, Berta Hernandez Trujol, did me the favor of reading through it. And she tried to be very gentle with me because it's the first time I'm sharing my work, with a colleague. And she said to me, Tanya, this is not the Cheryl Harris show. Your article is meant to showcase your thoughts. And I said, but what she has to say is so important. What she has to say is so informative. I can't not talk about her work in this piece. And she said, yes, but that's what the footnotes are for. And so I had to revamp it so that I paid tribute and gave credit where credit was due, but still managed to say a little bit of something about what I was thinking, as informed by your very helpful lens. So that there's my little short embarrassing story about my first sort of serious engagement with the piece as a writer myself. And what I wanted to share with you today is the way in which Cheryl's work has been very informative, not only sort of my thoughts about multiracialism and categories and classifications, but also within how these things play themselves out in Latin America, hence my participation in the Global Engagements panel. And there were two sentences in particular from Cheryl's article that inspired me, let's put it this way, to bring her light into issues of race in Latin America. And here they are. Whiteness is an aspect of racial identity, surely, but it is much more. It remains a concept based on relations of power, a social construct predicated on white dominance and black subordination. Following the period of slavery and conquest, white identity became the basis of racialized privilege and legitimated in law as a type of status property. And I'm here to tell you that this was also the case in Latin America. Now, what many people in the academy who are not familiar with Latin America or only hear about Latin America through Latinos in the United States, or maybe they just watch Univision, I'm not quite sure. But their perspectives, when I say that my area of interest, of one of them is issues of race in Latin America and the treatment of Afro-descendants, is to say, Afro-descendants? They think, well, aren't you all just sort of mixed? And so you're like this, like, mulata princess population, as opposed to having real black people. Right? Cue first slide. Zoom her up. Okay. So I have to say, no, we have real black people. That is to say, those that not only are Afro-descendant, but any person would not disagree with me about saying that there was no ambiguity, right, about the presence of Afro-descendants. And so this image that you're seeing here is of a Colombian woman from Colombia working in the gold mines. And it's actually a news clip, but the journalist was kind enough to share the image with me for the cover of the book that I did with regards to these issues in Latin America. Okay, and so when I say, no, we have real black people, and so we have real race issues in Latin America. It is not this mixed race racial paradise, contrary to what you may have heard elsewhere. I'm then sort of asked, well, how did they get there? Like, the thought is that Afro-descendants are only either in Africa, right, Caribbean, or in the United States. Like that the United States is the story of slavery. And so there's sort of this mystification about where these black people come from. Okay, cue second slide. And go immediately to the second one the second one for me, okay? Scroll down for me. Okay. All right. So here what you have is an image of the Atlantic slave trade patterns, right? And this is not new. You may have seen this before if you've taken black studies, etc., right? And so what this enables you to have a better image of is the way in which 90% of the approximately 10 million enslaved Africans taken to the Americas were brought to Latin America and the Caribbean, 90%. Whereas only 4.6 were taken to the United States. One historian actually estimates that the total number of African slaves imported into Brazil alone, right, just one country, Brazil alone, as 3.6 million. Right? In contrast, U.S. historians estimate that only 500,000 African slaves were imported into the United States and British North America. Okay? So there you've sort of got the how did they get there demystified for you. Now scroll back up to the first image. And here, I often get, okay, well, that's interesting. You mentioned Brazil. Okay, maybe there are black people in Brazil. I've seen some soccer players, maybe there. Colombia, right? But certainly not Mexico, right? So on the West Coast, this is particularly salient. And, people, but we don't have many black people in Mexico, so we have nothing to do with this. Yes, you do. Right? They were brought all over Latin America and continue to exist all over Latin America. Now, certainly not all in equal proportions, right? So, stepping into Ciudad Mexico is not the same thing as stepping into Rio de Janeiro. But at the same time, the African presence is there as well. And they're just not immigrants from other places. They're Mexicans. Okay. That's a story for another day. But I wanted you to be able to see the breadth with which they exist. This was a chart that was assembled some time ago that used a lot of NGO materials to try to estimate the numbers of Afro-descendants. They had to be estimated because so many census forms in Latin America omit a race or ethnicity question. We don't raise it, it doesn't exist. Right? We don't count it, you don't exist. Right? In any case, so what I wanted to do was to share with you, and now you can just put the my beautiful sister up on the screen for now. She's pretty to look at. Okay. What I wanted to share with you then is the ways in which Cheryl's insight about the ways in which whiteness as property was legitimated in law, right? That this centrality of the legal piece, right, is also central in Latin America and Latin American history. And that the pride that Latin Americans have so long taken that we did not have Jim Crow segregation, so we're not racist, is actually a shield for the ways in which law has been involved in the regulation of race in Latin America. So, in order to be concrete and to give real examples, I'll focus on just one nation, and you got to read the book to find out about everybody else, right? So, I'm going to take on Brazil, right? The nation with the highest number of Afro-descendants, a long history of race regulation through law, and so I'm going to use that as my case study to share with you in the time I have, right? When Brazil emancipated its slaves, the very last nation in the region to do so, 1881, right? Long after the U.S. Civil War, right? Okay. Its response, right, to the fear of a newly freed black population was like the rest of Latin America's. An attempt was launched, to whiten its population and institutionalize the valorization of whiteness. In Brazil, the whitening philosophy had a name. It was called branqueamento, and directly paralleled Spanish America's whitening philosophy of blanqueamiento, which just means whitening, right? So, like blanqueamiento in Spanish America, branqueamiento in Brazil was both an ideology and a set of practices for whitening the Brazilian population, and presumably modernizing the population and the nation. So modernization equals whiteness. The efforts to whiten the population were so extensive across the region that one scholar describes Latin America as having a white settler society and culture that continues to exert influence today in the opposition to the recognition and fuller inclusion of non-whites in civic society. But Brazil stands out among Latin American countries as the nation with the most extensive legislative network of racial restrictions and customs to regulate race after the abolition of slavery. And thus, this is why it serves as a useful case study for providing greater detail about the development of the customary law of race regulation, as a term I like to use. The first step in the national whitening campaign was legislating restrictive immigration laws, designed first explicitly to encourage European immigration, and second to prohibit or severely discourage the immigration of peoples of African, Asian, and indigenous ancestry. These two things happen in tandem. As early as the 1850s, with the growing international pressure to disengage from the slave trade and abolish slavery completely, the Brazilian legislature took decisive steps to encourage European immigration. A statute that year provided generous land grants to immigrants designed to encourage more European immigration. The same statute also denied land title to residents of quilombos, that is, land that had been occupied by the descendants of runaway slaves for generations. The provincial government of Sao Paulo then heavily funded the Society for the Promotion of Immigration. After the final emancipation of slaves, actually in 1888, and the dissolution of the Brazilian Empire in 1889, the legal preference for white immigrants would become more overt because of the distaste Brazilian elites had for the vision of African-descended peoples as paid laborers. Indeed, in official gatherings of the planter class anticipating the end of slavery, meeting minutes recorded the preference for white immigrants over what was called the indolence of the native population, then laboring in servitude as a, quote, decrepit race. Understanding the preference for European immigrants as racially motivated is especially clear when one observes that the Europeans who were recruited were not skilled laborers, and many were illiterate rural dwellers. Moreover, during the post-emancipation period when European immigrants were being sought, the wage labor positions available were for low-skilled laborers without education or professional training that could have been easily filled by the newly emancipated Afro-Brazilians had they not been viewed as, quote, unfit for wage labor. Indeed, newspaper classified advertisements explicitly stated, whites preferred. These racialized attitudes about the ability to work as wage labor were then reflected in regional legislative assemblies, such as that of Sao Paulo in 1888, where the desirability of white foreign workers was discussed along with the proposal to provide land grants to encourage their immigration. Accordingly, one of the first enactments of the new republic was an immigration decree by the president that excluded all members of the indigenous populations of Asia and Africa from immigrating to Brazil. This was at a time when overall immigration was at its height, and immigrants from Europe were allowed entry without even having to pay a fee. In 1921, the Brazilian Congress passed a similar law which specifically prohibited black immigrants from entering Brazil. When blacks sought to do so, they were simply denied visas. Large waves of immigration to Brazil coincided with the abolition of slavery in 1888, making European immigration a national policy by the late 19th century, with migrant numbers only exceeded by those of Argentina. If I could have taken them on as a case study too, but in any case. In fact, in 1889, Brazil enacted a law to grant automatic naturalization to the immigrants who migrated from Europe. Furthermore, the government expended funds to encourage European immigration with the payment of transportation costs. Sao Paulo administrative law also provided for state-funded housing, where food and hospital care was supplied, along with a cash grant that varied by the age of the European immigrant. Sao Paulo's state-funded immigration expenditures also included pro-immigration lobbying in European countries, providing farming tools, and the waiver of military service for the children of these immigrants. In 1888, just months before the final emancipation of slaves, the Sao Paulo Provincial Assembly authorized the government to allocate this plethora of immigration subsidies to a minimum of 100,000 immigrants. The dedication of governmental funds to the whitening project of European immigrations was so significant that by 1895, immigration subsidies took up 14.5% of Sao Paulo's annual budget, 10% of its 1896 budget, and another 10% of its 1901 budget. While the floodgates were opened for European immigrants, the continued ban on immigrants from the continent of Africa was broadly interpreted so as to exclude U.S. tourists of African descent who had never set foot in Africa, let alone had citizenship status in a country on the African continent. Furthermore, the Brazilian government continued to exclude U.S. citizens of African descent despite its flagrant breach of an 1828 treaty that stated that citizens and subjects of both countries, the U.S. and Brazil, have the right to reside and do business in one another's countries, travel. There will be a perfect, fixed, and inviolable peace and friendship between these countries in all their possessions and territories without distinction of people and places, except Afro-descendants. The racial restriction on Brazilian immigration law continued with the government of Getúlio Vargas from 1930 to 1945, and in his 1934 constitution, it would effectively limit immigration to whites only. The Brazilian Constitution also went on to effectively prohibit settlements by blacks or Asians regardless of their country of origin. This measure was presumably designed to curtail the immigration of Afro-descendants from other Latin American nations. We don't want ours, we certainly don't want yours. Provisions in the Brazilian Constitution designed to allow the government to prevent non-white immigrants from entering the country were reenacted in the 1946 Constitution and in a 1969 decree by the military government. The Branqueamento immigration project was so successful that in less than a century of subsidized European immigration, Brazil imported more free white labor than black slaves imported in 3 centuries of the slave trade. With the overt racialization of the immigration policy, Brazilian legislators and elite stakeholders were quite explicit about the desire to use immigration to eradicate blacks. Like Spanish America's Blanqueamiento projects, Brazilian white immigration was rooted in eugenics discourse that reinforced pre-existing Brazilian beliefs about the inferiority of Africans and their eventual extinction. For instance, in 1879, a parliament member, Joaquim Nabuco, stated, "As the black man and the white live together in the same society for hundreds of years, the former's black blood will tend to be absorbed, because it's weaker, into that of the latter, or it will disappear altogether as the one race gives up the field to the other, better prepared for the struggle of life." So as the numbers of European immigrants increased, so did the public intellectual support for eugenics. In 1912, the intellectual elite João Batista Lacerda, who was a presenter at one of these eugenics conferences, went on to predict that the Brazilian, I have 1 minute, that there will be no more Afro-Brazilians. Let me move on. Okay. So I will just simply say that time will not permit me to regale you with more details about Brazil's Branqueamento project and the similar attempts for blanqueamiento across Spanish America. Suffice it to say that across the region, in addition to white-focused immigration, there were post-abolition state customary practices of policing public spaces for the maintenance of racial segregation, excluding persons of African descent for places of public accommodation, imposing racist norms in public education, establishing biased regulation of African-based religions, treating them as cults, and structuring census enumerations to marginalize persons of African descent. Don't count them, they don't exist. In my book on this topic, I call that the customary law of race regulation that continues to influence the contemporary investment in whiteness and resistance to racial equality efforts in Latin America. Whiteness as property was formative in my research into Latin American race relations, and it continues to be salient to all my research these 20 years later. Thank you very much.
Hello, everybody. It is a great honor to be here to help all of you celebrate Professor Cheryl Harris's many accomplishments, including the article that we are here to commemorate. I also have to thank Asla for liberating me from having to talk about local government law, something about which I know absolutely nothing, and thus sparing me humiliation. The title of my talk today is Enchantment, Engagement, and Estrangement, 3 Moods in the Legal Struggle for Justice in Palestine, Israel. So Professor Harris, in the path-breaking piece that we are gathered here to honor, differentiated between whiteness as a category, entitling one to own African Americans as property, and whiteness as a category endowing one with superior claims to property in land over Native Americans. Now, much could be said about the topic of Jewishness and property in Israeli law and state policies, particularly as it parallels this second form of racial privilege identified by Professor Harris. But I know that Nora Arakat has already done some of that work yesterday in her presentation. So I'll say just a little bit about Jewishness as property in in Israel. So first of all, I would commend you to the two articles that I provided the organizers here. One is an academic article called Land, Law, and Legitimacy in Israel and the Occupied Territories. It also happens to be 20 years old. And in it, I go into some detail regarding the similarities in legal mechanisms and rationales for dispossessions of Native Americans and Palestinians. The other piece is a short narrative about conversations that I've had with the current residents of my grandfather's home in West Jerusalem, which was expropriated under the absentee property law in 1948, about which Nora spoke yesterday. That home, incidentally, was once inhabited, at least part of it, one floor of it, was inhabited by Golda Meir during her tenure as labor minister for Israel. And she is, of course, infamous among Palestinians for her denial of our existence as a people. A famous claim that she made, widely quoted. She was also reputedly responsible for the erasure of the tiles on the front of my family's home that marked it as Palestinian. And it reminds us that Palestinians, ironically, remain in their land in significant numbers, and in fact, if not today, soon will constitute a majority of the population under Israel's dominion. Our discursive erasure and denial of peoplehood, therefore, remains a contemporary necessity. One poignant example of this was evident just this past week in a report from Israel's Population Authority on the most popular names for newborns in Israel in the past year. Anybody care to venture a guess as to what the most popular name was? Muhammad. Okay, this is a well-educated audience. You know, therefore, those of you who have been up on this news, that the Population Authority only reported, in fact, the most popular Jewish names, as if all of those Muhammads either didn't exist or didn't matter. But so as not to simply amplify on what Nora said yesterday, for the remainder of the time I want to do something a little bit different, and that is to talk about the evolution in thought and practice of the community of scholars, lawyers, activists, and others who have sought to exploit law or use law as an instrument for achieving justice in Palestine, Israel, and to identify influences where I can, identify influences, resonances, and parallels between this evolution and critical race theory. Now, following Cheryl's example, I will offer a partly personal narrative, only interesting and worthwhile to the extent that it's exemplary of a community experience. And I refer here primarily to Palestinian civil society. And I do believe that, that what I have gone through in my own thinking is, to some extent, a mirror of what has gone on among those around me. Now, I talked about the evolution of three moods, and that implies change over time. And there is indeed a kind of chronology here. We have moved from enchantment with law to engagement in law to estrangement from law. But I choose moods over phases to indicate fluidity and ambivalence, and the possibility, for example, of engagement in law or engagement with law, even within a dominant mode of estrangement from it. So to start personally, I came of age in terms of political consciousness in Northern California in the late 60s and early 70s. My family was active both in Palestinian issues and in the anti-Vietnam War movement. I had a seminal experience in hearing David Hilliard, Chief of Staff of the Black Panther Party, in probably 1968. Believe it or not, my mom, I was probably 14, my mom took me out of school to go see David Hilliard, thinking, you know, George, you ought to be exposed to a lot of different perspectives, and you're going to hear from a Black Panther. So we went to an anti-war rally that was held at Sacramento State. Someone, possibly even me, asked him a question about Palestine. And unlike your typical pep, That's a progressive accept Palestine. That's what we call them in my community. David absolutely ran it down. No equivocation. He was shockingly well informed, shocking to me, and analytically sound. You could say, in a way, from that day forward, I started to understand what solidarity across struggles really meant. This was also a period when lawyers like Charles Gary, Leo Branton, William Kunstler, and others played prominent roles in defending the Panthers and other political activists and in advancing other progressive ideals. So it was not hard for me and for many of my era to be enchanted with law's apparent liberationary promise. Now, to be fair and accurate, enchantment involves some hyperbole. Neither I nor anyone else in my community has ever had illusions about law's role. After all, Israel ruled its Palestinian citizens via a system of martial law for the first 18 years of the state, and immediately instituted an equally draconian system in the West Bank and the Gaza Strip when they were occupied just 1 year later in 1967. Similar laws within Israel and the occupied territories were used to appropriate Palestinian lands and open them for Jewish settlement. And aside from the comparison to Native Americans, that's what that article that I provided really is about. Like critical race theory, some of the earliest work done in my community was to deconstruct how Israeli law and its legal system functioned to advance colonization of Palestinian lands and suppress Palestinian resistance to that process. So I think, for example, of the book written by Sabri Jirius in 1969 entitled The Arabs in Israel, which did what I just described. So the question for us has always been law as power or law as justice. Which of the two Janus faces of law will show and under what circumstances? Now, there was I would say, a mood shift in the late 70s and early 80s toward sort of what I've called enchantment, again, with an asterisk. There were several notable events of that year. There was what is often called the Ilan Moreh case in the Israeli High Court, in which, for the first time, a challenge to the establishment of an Israeli settlement in the West Bank was successful, and a settlement was dismantled. In that same year, an organization called, well, it was called at the time Law in the Service of Man, later became Al-Haq, was founded in Ramallah in the West Bank. I worked there in the summer between my second and third years, that was in 1982, in law school, that is. There was a palpable sense of excitement, purpose, and a vast sense of a vast scope of possibilities for work and action. And I should note, of course, that this coincided with and was, in a sense, a local expression of the worldwide rise of human rights discourse and the attendant burgeoning of human rights NGOs internationally, not just in Palestine. Enchantment, of course, naturally led to engagement, by which I mean primarily litigation. Within Israel itself, outside in the domestic courts of foreign nations, including the U.S., sometimes under universal jurisdiction principles, and eventually in 2003, 2004 to the International Court of Justice. Now, the results of all of this litigation were almost uniformly disappointing. There were a few qualified victories, which if you're curious, ask me about. But for every victory, there were tens, if not scores, of losses. And even favorable rulings seem to have little impact on the ground. Just two quick examples. So in 2000, 2001, I can't remember the exact date, the Israeli High Court banned 4 forms of torture. This was a big deal at the time. Allegations of torture arose very soon after the occupation began in 1967. The Israeli government always denied that torture took place. Eventually, it came out, yes, in fact, an Israeli government commission was appointed and determined, in fact, torture had been going on routinely for years, and this is, of course, torture of Palestinian detainees. And so this was, held up as a sort of a landmark in Israeli law. Well, in fact, physical abuse of Palestinian detainees is absolutely routine. To this day, we saw that, for example, this summer on cell phone video of the young kid from Florida, the Palestinian American, who you saw being beaten to a pulp by Israeli soldiers. That kind of abuse at the point of arrest, further abuse upon interrogation, detention, interrogation, continues to be absolutely routine despite this high court ruling. Need I say the settlement project has hardly missed a beat since the Elon Morey case of 1979. The legal principles enunciated in that case really didn't provide protection against ongoing colonization, expropriation of Palestinian land. New methods were devised, and the colonizing juggernaut continued unabated. Not to mention litigation in Israeli military courts, where in a recent year the conviction rate was 99.74%. So there was a recurrent debate within my community, and which I joined in several writings, whether the legitimation costs of litigation in Israeli courts exceeded the meager gains, recalling, at some level, in any case, Derek Bell's interest convergence thesis. Now, unfortunately, the results outside were hardly more satisfying. I will just tick off a list in the interest of time. Unsuccessful cases in Belgium for the prosecution of Ariel Sharon for his role in the Sabra and Shatila massacres, Ariel Sharon and others. The attempted arrest of Israeli General Doron Almog in the UK. Civil suits against Israeli Army Chief of Staff Yuval Diskin and Shin Bet head Avi Dichter here in the United States. All of these cases came to naught. Now, the sort of the high water mark of engagement was the case brought to the International Court of Justice to challenge the legality of the separation wall that Israel began building in 2003. This actually led, in legal terms, to a sweeping legal victory for the Palestinians. But in the months and years following the judgment, it became increasingly clear that it would have little or no impact on the ground. Take it from me, I'm skipping a lot here to try to finish in my time. So this greatly increased cynicism among Palestinians regarding the role of law in struggle and in the capacity of courts to bring them any closer to justice. So we now reach the current period of estrangement from law. This is particularly evident among young Palestinians. Let me just read you a quote from a piece called Against the Law, Mezna Qatu and Karim Rabia, in a magazine you may know, Jacobin. Almost all prominent Palestine organizing, including the Solidarity Movement, bases the struggle and its claims on international law. Indeed, the 2005 call for boycott, divestment, and sanctions by Palestinian civil society groups was made in order to pressure Israel to adhere to international law. We support BDS as a potentially fluid and inclusive solidarity tactic, but we consider it problematic to pivot movement strategy on bodies of law that emerged in order to regulate imperialism, and that often functioned to legalize Israeli colonization and colonialism. Okay, so again, summarizing a little bit, we are at a stage of more skeptical, critical, and in some ways open-ended approaches to imagining law's possibilities, extending it out of the courtroom to include discourse, scholarship, legislation, and other realms. I, for example, have recently argued in a piece that will come out soon in favor of what I call an integrated strategy for liberation in Palestine that situates law within political struggle and also gives some examples of hopefully more imaginative uses of law. Now, I want to end by, well, I'll just say there is no conclusion as such, because we as a community are in flux, still struggling with how law can both oppress and liberate us. But now let me finish by circling back to the question of solidarity that I earlier touched on, and to note new possibilities for joining our struggles on even more tangible grounds beyond mere empathy. In this contemporary globalized world, Israel has become a leading exporter of technologies of repression. In the last decade, for example, it has trained many police and other emergency forces in the United States in anti-terror techniques, part of the trend toward militarization of domestic police forces. And this includes some of the upper-level staff from the police department of Ferguson, Missouri. Israel also signed an agreement with Brazil to provide security training and materials, drones and whatnot, during the World Cup and during the upcoming 2016 Olympics that evoked considerable popular opposition within Brazil. So in or outside of the courtroom, then, perhaps we will be finding cause to work together soon and to jointly strive to make law an instrument of justice, not just power. Thank you.
Okay. You're everyone. I'd like to begin by acknowledging that we are on Native American land, and I'm honoured to be here, and I'd like to thank the Critical Race Program for inviting me. Where do I begin with Professor Cheryl Harris? My intellectual debt to her is enormous. She is what we would call, we have a Deadly Black Women's Club in Australia, and she's a triple B, black, beautiful and brilliant. Not only am I indebted to her for her seminal piece, but also she taught me the fine art of drinking mojitos and chocolate martinis. So I want to begin by saying that her work has informed the development of the Australian critical race and whiteness studies in a multitude of ways. And I think a big part of that is because Cheryl's work really provides us with an understanding of how the law operates as a regulatory mechanism in the everyday. She takes us out of the courts. She takes us beyond the idea of legislation. She actually talks about the way in which we as subjects are disciplined and regulated by the law in ways in which very few pieces of legal scholarship do. In this presentation, I want to demonstrate the importance of her work by showing how it has been operationalised in analyses of whiteness and identity formation, whiteness as public representation and personal property, and whiteness and sovereignty. And I do this in hope that I can also give you some information about Australia, which most people don't really know about. Do you know where it is? It's like... Okay, so Australia has no treaties with Aboriginal people, and the British took possession of the continent under the legal concept of terra nullius, land belonging to no one. During the first 100 years of frontier wars and subsequent colonial occupation, it was the intersection between race and property that played a definitive role in constructing and affirming Indigenous or Aboriginal people's racial and economic oppression. The incarceration, removal and extermination of Aboriginal people were validated by regimes of law based on the British assumption of sovereignty, ensuring, to quote Harris, only white possession and occupation of land was validated and therefore privileged as a basis for property rights, end of quote. Now, the Australian nation continues to represent itself in law and popular culture as a white sovereign nation. What has been central to this national identification is how land is the source of white imaginings of a distinctive Australian identity. First, the land was represented as a site requiring control, and then as the stage or page on which the progress of civilization was played out and written in through the heroics of the explorer journeys or their heroic narratives. Most famously and persistently, the land was summoned to play its part in settlement myths of white men and women made for the land by having lived, worked, suffered and died there. The relationship between land and people infuses national identifications, usually performed through an iconic white heterosexual male body that is venerated as the explorer and pioneer who faced adversity while taming the environment. This body represents the battler who made the land productive, as the soldier who fought to protect the land from invaders, and the sports hero who signifies the new white body that has come out of the land. This is in contrast to the Aboriginal sports hero, whose body represents reconciliation and race rather than the nation itself. At the 2000 Sydney Olympics, media represented Cathy Freeman as running for Aboriginal reconciliation, as opposed to Ian Thorpe, who swam for the nation. Through this discursive move, Aboriginal people are represented as being in a liminal and dispossessed state, while white men's ownership of the nation is affirmed. The white nation as an imagined community requires a physical and geographical context for constructing its identity. In this way, the legal fiction of terra nullius indelibly marks configurations of national identity. This is evident in Australian films, ranging from The Sentimental Bloke through to Walkabout, Picnic at Hanging Rock, The Last Wave, Crocodile Dundee, The Man from Snowy River, Mad Max 2, Priscilla and the Castle, where myths of national belonging and identity are clearly tied to land. Apart from the castle, these films offer the possibility of an Aboriginal landscape, which is removed from the politics of Indigenous sovereignty and inadvertently works to reproduce the legal fiction of terra nullius and white sovereignty. Aboriginal people are represented as being in and of the landscape. They evoke an affective state and are deployed to refigure, quoting Povinelli, Australian modernity through ancient traditions, sensual and enduring, lying under the physical and social space of the nation, end of quote. So Aboriginal tradition is presented as an imagined thing that exists in a prior state, offering the white imagination a positive reminder of its own beginnings and resilience in an empty and unoccupied landscape that erases a history of over 200 years of dispossession, neglect and abuse of Aboriginal people. The relationship between whiteness as property and the law manifests itself in the latter part of the 19th century in the form of comprehensive discriminatory legislation tied to national citizenship. Colonial and subsequent governments limited naturalised citizenship to white immigrants, while blackness was congruent with Aboriginal subjugation and subordination. Whiteness was perceived as being synonymous with freedom and citizenship. The right to determine who was allowed into the country, and therefore who could belong, was exercised by a white male British constituency at the heart of the nation. They legally ensured the social reproduction of whiteness as property through the Immigration Restriction Act of 1901 and the White Australia policy, which until the 1940s gave preference to white British, Canadian, American or New Zealand migrants. As Harris argues, and I quote, according whiteness' actual legal status convert an aspect of identity into an external object of property, moving whiteness from privileged identity to a vested interest, end of quote. While white proprietariness was exercised in defining who could and who could not be white, and by 1949 the racial category of white was expanded to include a variety of Eastern and Central European refugee groups. The courts played an active role in enforcing this right to exclude, in the sense that the courts protected whiteness as they did any other form of property. The integration of various Europeans into a white Australian identity coalesced around Anglo norms, was enabled by a worldview that defined Aboriginal people up until the 1960s as non-citizens. The White Australia policy, despite being legally revoked in 1973, continued in practice for many years. And I just want to speak to the panel that I went to previously on colonialism, that one of the ways in which those who become white within Australia, and I dare say this would also apply here, is that they function as the perpetual foreigner within, in that they actually serve to legitimate the state through citizenship. So the conferring of citizenship on you actually means that you basically can then belong, and you are in fact actually indebted to the state. So it legitimises the theft of Indigenous land through that very move. So the development of a white national identity and racial hierarchy was salient in establishing and maintaining a system of Aboriginal subordination. Defining who was and who was not an Aborigine in law also operated as a marker of those who were or were not white. Many laws sanctioned discriminatory treatment based on racial categories. Aboriginal people were not allowed to travel without papers, were not allowed to own property. Is this sounding familiar?
Yeah, very.
Were not allowed to be educated, were not allowed to vote, were not allowed to earn award wages, and were not allowed to marry without permission. The law was a crucial instrument in developing racial classification. By defining race through physicality, the law could apportion and determine social status according to race, thereby enabling systemic discrimination by providing definitions of racial group membership. To quote Harris again, rights were for those who had the capacity to exercise them, a capacity denoted by whiteness. So apportioning rights and race in this way continues to this very day. From the early 19th century to the end of the 20th century, there have been approximately 700 pieces of legislation specifically concerning Aborigines and 76 definitions of Aboriginality that have been identified. So race, blood, territory, habitation and descent usually quantified these definitions. In the latter part of the 20th century, the definition of Aboriginality relies on subjective and communal identification. But despite the range of definitions, they have all served to meet the changing interests and aspirations of a white possessive nation. As Aboriginal lawyer Mick Dodson states, they were useful, quote, where there was a need to create a boundary between primitive and modern man, to legitimate progress, to justify particular economic and political developments, to control, manage or assimilate Indigenous cultures. Aboriginality was made to fit the bill. At the most immediate level, constructions of Aboriginality are directly linked to policies of management and control of Aboriginal peoples. They form part of the framework in which the state can act upon and justify its treatment of Aboriginal peoples, however disrespectful or abusive of our rights it may be. End of quote. So patriarchal whiteness provides the norm and measure for conferring ownership of an Australian citizenship and the privileges, legal benefits and entitlements accrued to that status. In this way, whiteness became and is a form of property. As Harris argues, quote, property commonly refers to things owned by persons or the rights of persons with respect to a thing. It is more than a relationship to the tangible and material. It embraces metaphysical, tangible, intangible rights such as reputation, status and identity. In Australia, unlike whiteness, the law has not converted Aboriginality from being an aspect of identity to an external, intangible object of property. I refer to the case of John Bailey and Leon Carman, two white men who faced court over impersonating an Aboriginal female author of the book My Own Sweet Time, after it had won a National Literary Award. The New South Wales Police charged Bailey with making a false and misleading statement involving the author, Wanda Coolmartry, who was a fictitious person invented by author Leon Carman and Mr. Bailey. The Coolmartrys but are actually an Aboriginal family. The charges against Bailey and Carman were dismissed by the Central Land Court in Sydney on the grounds that there was no prima facie case to support the fraud allegations. This is despite the fact that both white men admitted deceiving the publishers of the book, Magabella Books Aboriginal Corporation, and the sponsors of the Nita Mae Dobie Award. In this case, a white private identity based on racial hierarchy and privilege was legitimated as public identity in law because there were no precedents. The court's findings confirm that no harm can flow and no reputation is defamed when white men impersonate an Aboriginal woman. Through its decision, the court recognised and affirmed patriarchal whiteness as public reputation and personal property. The law has been active in enforcing racial categories and privileging whiteness by relying primarily on white reference in formulating the norms and expectations that become the criteria of legal decisions. The rules governing discourse in the legal idiom are not race neutral, and this is evident in Australia's law's native title regime. As I have argued elsewhere, the existence of Aboriginal proprietary rights in land was recognised by the High Court of Australia in Mabo v Oars v Queensland in 1992. However, Professor Kent McNeil argues that the rule of extinguishment used by the High Court in Mabo 2 decision is inconsistent or was inconsistent with the broad rule of common law. The High Court's interpretation that at common law, native title can be extinguished by the nation state if it is inconsistent with its sovereign power transgresses the common law rule that the Crown cannot derogate from the vested interests of its subjects. McNeil argues that it doesn't matter whether those rights were derived from Crown grants or adverse possession or customary law. That is a fundamental limitation on the executive power. Effectively, the High Court in Mabo 2 invented a rule of extinguishment that did not exist under common law, so that inconsistent grants could extinguish native title prior to the Racial Discrimination Act of 1975. This rule of extinguishment allowed the Crown to retrospectively derogate from the vested interests of its Aboriginal subjects. In doing so, the Court's decision protected whiteness as property by affirming the legitimacy of white sovereignty and creating in law a hybrid of settlement that diminishes but does not erase terra nullius. This is how the courts ensured all titles to land accumulated by colonists and their descendants prior to 1975 became legal. Any remaining unalienated Crown land could be claimed under native title. And I might add, this does not include a right to reside. Full stop. So the Court's findings in the subsequent Wick decision affirm these two principles in recognising that while native title and Crown title can coexist, any inconsistency means a deferment to Crown title. These principles in law established a legal premise that no successful native title claim can be made which diminishes the existing title of any other Australian. The Court's decisions affirmed whiteness as property through ensuring that the sovereignty of the nation was not diminished and the benefits and privileges accrued through the theft of Aboriginal lands could continue to be conferred and protected. Thank you.
Okay, so I want to begin by expressing how thrilled, grateful, and somewhat terrified I am to have been included in such a distinguished panel. So thank you very much to the organizers for including me, and thank you so much, Cheryl, for your amazing body of work. In my presentation, I have two objectives. The first is to explore the broad applicability of whiteness as property, as well as Cheryl's prescience regarding the potential that affirmative action holds for addressing racial inequality, and I want to do this in the context of South Africa. And then the second thing I want to do is to highlight some of the tensions that remain unresolved, even when the remedial potential of affirmative action is pursued. Again, using South Africa as a case study, and then also with some reference to Zimbabwe. If I run out of time, I might have to do some of this in Q&A. So I want to begin by highlighting the historical overlap between the United States on the one hand and South Africa and Zimbabwe on the other in the trajectory and nature of racial subordination, because the historical context is vital to the development of Cheryl's theory of whiteness as property. And the other panelists have done the same thing. Historical context is just so important. In her article, Cheryl maps how white domination produced substantive racial inequality in material terms, particularly in the ownership of property and land in the United States. Though there are important differences, a similar history is shared by South Africa and Zimbabwe. Prior to the independence of both these countries, whiteness became the precondition for the acquisition of property. In South Africa, a series of laws beginning in the early 20th century culminating in a policy of apartheid effectively entrenched profound racial inequality. Non-whites were stripped of their citizenship, forcefully relocated to designated homelands, and subjected to inhumane conditions of existence. A hallmark of the colonial and apartheid legacy was the theft of massive tracts of land, dispossessing blacks, who were prohibited from owning land in much of South Africa, and enriching whites, whose whiteness was property, in all the ways that Cheryl lays out in her piece. For example, in 1994, when South Africa finally gained its independence, some of the figures suggest that 87% of the land was owned by whites, who at the time represented less than 10% of the population. In Zimbabwe, similarly, white colonial expropriation of land dated back to the 19th century, where communal property arrangements of the indigenous population were rendered invisible, and the only property rights ultimately recognized by law were the individual titles held by white settlers. So in 1979, which is the year before Zimbabwe gains its independence, whites made up about 5% of the population and owned 70% of the most fertile land in the country. So following the tradition of last night, I want to highlight the state of affairs in Zimbabwe and South Africa when Whiteness as Property was being written, and this is 1993 when it's published. In South Africa, Nelson Mandela had been free for 3 years, and the nation was in the throes of negotiating their transition to democracy, including determining the legal framework that would facilitate redress for racial inequality. And this is a process that Cheryl was actively involved in, and I'll leave it to Albie to discuss that. Technically, I should leave everything to him, given that he was a constitutional court judge, but here I am anyway. And then in Zimbabwe, on the other hand, where I was a teenager watching the events in South Africa unfolding on TV, it was 14 years after independence. And land reform in Zimbabwe had stalled for many reasons, including the failure of a willing buyer, willing seller approach to land reform, and lack of funds on the part of the Zimbabwean government to compensate farmers, even when it was able to compel the sale of land. This is all useful background for points I'm going to return to shortly, and in the final part of my presentation, I'm going to come back to the current status of land reform both in South Africa and in Zimbabwe. But right now, I want to turn to the affirmative action blueprint that Whiteness as Property spells out, as well as how this blueprint is evident in South Africa's thriving affirmative action jurisprudence today. At least one of the fundamental questions that Whiteness as Property engages, even if it doesn't definitively answer it, is the following. Can there be a liberal rights discourse that disrupts and remedies racially entrenched inequality? One answer to this question that's evident from Cheryl's piece is that for as long as law fails to confront and dismantle whiteness as property, it can do very little to dismantle racial inequality. If anything, it entrenches it. And to illustrate her point, she unpacks US jurisprudence on affirmative action, which quite frankly is heartbreaking. So heartbreaking, in fact, that I won't recount it here because I might cry. But in a nutshell, US courts have systematically destroyed any potential for affirmative action policies as they stand right now to fight racial inequality in this country. What I'd like to focus on instead is how South African courts, by virtue of a constitution that explicitly is committed to effecting societal transformation, have taken a very different route. One, in fact, that Cheryl spells out in her article in 1993. In Whiteness as Property, Cheryl argues for the reimagination of affirmative action. And I quote, the beginning, let me start again. In Whiteness as Property, Cheryl argues for the reimagining of affirmative action as, and I quote, beginning the essential work of rethinking rights, power, equality, race, and property from the perspective of those whose access to each of these has been limited in their oppression. And she also argues for the location of affirmative action within a distributive framework, one that privileges interrogation of entitlement and fairness rather than obsessing over guilt and innocence. Foreshadowing things to come in the article, she actually pointed to South Africa as offering a hopeful alternative universe, and even cites the work of Justice Albie Sachs' own scholarship on the transformative potential of affirmative action. So let's fast forward to 2014. Almost exactly a month ago, the Constitutional Court of South Africa issued a decision in the matter of South African Police Service versus Solidarity on behalf of R.M. Barnard. I'll call it the Barnard case. At issue in this case were the actions of South African Police Service taken pursuant to the Employment Equity Act. This piece of legislation requires all employers to ensure that suitably qualified employees from designated historically disadvantaged groups are equally represented in each working category by a respective employer. This act basically lays out the specific measures employers must take in the pursuit of affirmative action, including the elimination of employment barriers, diversification of the workplace, retention and development policies, and appropriate training measures. Based on the requirements of the Act, the South African Police Services had set employment equity targets reflecting the national demographics of the country. So turning to the facts of the case, Mrs. Barnard was and is a white South African member of the South African Police Service. In 2005, the National Commissioner advertised a promotion position for the rank of superintendent. Mrs. Barnard and 6 other applicants responded to the advertisement, and she and the others were interviewed by a panel of racially diverse senior police officers. She scored the highest in the interview. Her score was 86.6%. And the panel recommended her as the number 1 on a shortlist of 4 for the position of superintendent. The only black to make the shortlist of the 4 has scored 17.5%, less than Mrs. Barnard. And the panel believed that the appointment of this black male would compromise service delivery within the police department. The panel presented this recommendation that the job should go to Mrs. Barnard to the division commissioner. And the division commissioner declined to support the recommendation. His reasons were that black men and women were underrepresented in the division concerned, and appointment of the top 3 white candidates would only exacerbate this. So for the reasons of employment equity, he decided that the vacancy would remain. He didn't employ Ms. Barnard. 6 months later, a similar position vacancy was advertised, and again, Ms. Barnard applied. She and 7 other candidates were interviewed and shortlisted. So 4 were African men, 1 was an African woman, 1 was a colored man, and 1 was a white man. And we can talk during Q&A about how black is defined in the South African context. In any case, again, she ranked first on the shortlist, and second to her was an African man who scored 7.3% less than she did. The panel remarked that Mrs. Barnard displayed a distinct brand of passion and enthusiasm vital to service delivery needs of the police service. This time, the division commissioner, who prior to this event had denied to endorse the recommendation of Ms. Barnard, actually did endorse her recommendation. And his reasons for doing so were that failure to promote Ms. Barnard after 2 rounds of application would foster the wrong impression, and that her appointment would advance the service delivery goals of the police department. So the division commissioner made the recommendation that Ms. Barnard be appointed, and he made it to the national commissioner, who took the view that the recommendation presented to him did not address the representativity requirement, and that re-advertising the post would not be detrimental to service delivery. After this second time of being passed over for the promotion, Ms. Barnard chose to litigate, and the core of her claim was a violation of her right to equality under the South African Constitution. She argued that as a white person, the differentiation she was subjected to amounted to discrimination against her by the police on account of her race, and that the discrimination was unfair and could not be justified on the grounds of the requirements of the job or the affirmative action policy pursuant to which the National Commissioner had acted. The case eventually made its way to the Constitutional Court of South Africa, and the question before the court was whether the National Commissioner decision was unfairly discriminated against Ms. Barnard. Now, in the judgment of the Constitutional Court, which I have to say, for people who are depressed by reading U.S. Supreme Court jurisprudence, I highly recommend the South African Constitutional Court. It's really good for the soul and reestablishing faith in law. But in any case, the judgment of the Constitutional Court begins by highlighting how South Africa's constitution was designed to confer more than mere formal equality. And in a passage that reads as though it would have come straight out of Whiteness as property, Justice Museneke writes the following, and I quote, "At the point of transition 2 decades ago, our society was divided and unequal along the adamant lines of race, gender, and class. Beyond these plain strictures, there were indeed other markers of exclusion and oppression, some of which our Constitution lists. So plainly, it has a transformative mission. It hopes to have us reimagine power relations within society. In so many words, it enjoins us to take active steps to achieve substantive equality, particularly for those who were disadvantaged by past unfair discrimination. This was and continues to be necessary because whilst our society has done well to equalize opportunities for social progress, past disadvantage still abounds." In stark contrast to U.S. jurisprudence, end quote. In stark contrast to U.S. jurisprudence, the baseline is understood as one of systemic disadvantage, where the role of law is to begin the dismantling of racial privilege. The South African Constitution explicitly states, and I quote, "To promote the achievement of equality, legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination must be taken." So ultimately, the court found against Ms. Barnard, finding that the National Commissioner's attempts to achieve employment equality pursuant to the Employment and Equity Act were rationally and reasonably pursued. So that's good news. And in essence, the transformative jurisprudence that's foreshadowed in Whiteness and as property is thriving in South Africa. I want to conclude by looking at some of the limitations, though, that nonetheless remain even when you have an affirmative policy that is more transformative than not. And Whiteness as property notes that affirmative action programs alone cannot be the full solution to deeply entrenched structural inequalities. There's perhaps no other area where the limits of the liberal rights regime to address substantive inequality and where the persistence of whiteness as property is more evident than in the area of land reform. As mentioned, in 1994, 87% of South Africa's land was owned by the 10% white minority. Land ownership remains dramatically unequal, and precise figures are really hard to come by because they're heavily contested. One scholar notes that under the advice of the World Bank, the South African government was to redistribute 30% of the land by 2001. By 2010, it had only redistributed 8% of that 30%. South Africa's constitution enshrines a right to property and requires compensation for any expropriation. South Africa has pursued a willing buyer, willing seller approach to the acquisition of land for redistribution, and some argue that a combination of the reluctance of land-owning whites to sell and underfunding of the land restitution program has played an important role in stunting land reform efforts. There are those who argue that South Africa's transformative constitutionalism is still liberal constitutionalism and is not up to the challenge of providing a framework to eradicating the radical racial inequality that persists. For those of you who follow South African elections, you're aware of the meteoric rise of a party named the Economic Freedom Fighters, who, despite forming less than a year before the 2014 elections, won 6% of seats in parliament. A core feature of the EFF's platform is the nationalization of land and its compulsory seizure from whites and other elites for the benefit of the majority. The EFF points to Zimbabwe as a model for land reform. And this should raise concerns, perhaps, for many of you. As many of you will recall, Zimbabwe was in the media beginning the year 2000, after Robert Mugabe pursued a policy of forced and ultimately violent removals of white farmers, all in the ostensible name of returning land to dispossessed blacks. While we must rightly question the motives of Robert Mugabe in pursuing violent, forced removals, and while we must interrogate the means and outcomes of his enterprise, it's difficult to deny that the continuing appeal of the rhetoric he used to motivate land seizures. It's difficult to deny the continuing appeal of the rhetoric that he used to motivate land seizures, which in large part lies in his purported attempt to disrupt whiteness as property in South Africa. Thank you.
I used to wonder each day when I went to court, to my work at the Constitutional Court in South Africa, why I had a deep sense of elation. It's a beautiful building, the result of an international competition won by some young Durban architects and a town planner in Johannesburg, under the theme of justice under a tree, the traditional African way of resolving disputes. So it's great to go to work when you just enjoy the physical environment and you feel the symbolic quality of the building that you're in. But that didn't explain something quite deep. I loved going to work because the court was situated at the meeting place between Hillbrow, those of you who know Johannesburg, densely crowded, problematic, bright, filled with people from all over Africa, on the one side. On the other side, the beautiful northern suburbs, not a poor person in sight, and on the third side, the bureaucratic city. They linked on Constitution Hill. That explained it in part. I loved going there because, quite strongly, we built our court in the heart of the old Fort Prison. Maybe the only court in the world. Jails have been used to lock up people and even to try them in jail, but now this was taking the site of the most notorious place of pain in Johannesburg, where African men in particular disappeared. And that's where we built our court. We say with a very dubious pride, we South Africans have the only prison in the world where both Gandhi and Mandela were locked up. No one else can make that claim, and that's where we built the Constitutional Court. So there's an interaction between the past and the present, and that's powerful. And I felt that, and I loved that. Very, very deep. But there was something even more profound. Something, and I'm very, very secular, but something almost spiritual. A sense of elation I had when I went to the court. And then I realized almost everywhere where I go in South Africa, even a couple of decades after the wonderful new constitution, after the scrapping of all the apartheid laws, the tearing down of the signs, the deracializing of so much of our landscape, habitations, places of entertainment and so on, almost wherever I go in South Africa, to this day, I feel I'm a white man in a white area, maybe a white man in a black area. It's all those indefinables, the intangibles that are in sometimes the layout of the streets, the character of the buildings, the history associated, the names of the streets. I feel that, and with a sense of sadness, realizing that it is taking a long time. We've done amazing, wonderful things, but it's still that sense of location. It's not whiteness as property, it's property as whiteness. In a sense, it's a legacy that's there, and you feel it. But when I went to the Constitutional Court of South Africa, for the first time, I felt I'm Albie. I'm going to work. And we'd created a space. It was a physical space, an intellectual space, a working space that somehow captured that theme of non-racialism, to some extent non-sexism in our Constitution, not simply as the absence of formal discrimination and exclusion marginalization, but as the representation, the living out, the experiential side, if you like, of people coming from different backgrounds, not neutralizing ourselves to become non-racial, that is, non-personality, non-historical, non-located human beings, but we bring in what we are, what we feel, how we see the world, our culture, our tastes, our languages. We bring it in and we share it in a way that hadn't been done in our country before. And I must say, when I walk through the United States, I have similar feelings about being a white person in a white space, by and large, in many, many parts of the country. And in London, I have that feeling. It's not unique. But there was something unique and special and entrancing and liberating and marvelous for me going to work. At first, I wasn't even sure why. And then I realized that there was something that went beyond simply the beauty of the building, the historical meaning of the place. It was the new South Africa, if you like, the embryo of a new vision, imagined space, functioning in practice, and doing something that wasn't just fun and entertainment, a theme park, but dealing with establishing the core elements of the new public morality of our society. And it didn't just come to pass. We worked at it. We imagined it. We theorized it. We had an international competition for the building, a blind competition. It's quite daring for public works to have a competition of that kind. And the jury had very strong lay representation. And the key person on the jury was Tenji Mtenso. She said, "Why did you put me on the jury? What do I know about architecture?" She said, "You saw there were only men," which was absolutely correct. She was the head of the Commission for Gender Equality under our new constitution. She'd been in the underground, in the resistance. She'd been a military commander in Mkhonto Wesizwe, armed wing of the ANC. She's now back, part of the new constitutional project in South Africa. She's on the jury. And then she starts speaking. And she says, "I am my mother," that's her mother. "My mother is terrified of all the big buildings belonging to the state, the big, powerful public buildings. She's terrified of even the commercial buildings in downtown Johannesburg. She feels she has to go round the back entrance, or if she comes in, she has to apologize or explain why she's there." And she said, "We want a building that my mother," and her mother used to be a char. She would take in washing from white families to send Tenji to school, to university, and so on. "We want a building that when my mother is approaching, the building has a face that's not frowning, but a face that is smiling. And the buildings, the places, the spaces in our country frown at my mother. And this is the first building of our new democracy, and this building now should be a smiling building." And then when we saw this design, it was number 62 or 94, it was just a piece of paper with a number. Tenji said, "That's the building we want, just as under a tree. It will be friendly and warm and welcoming." And so we imagined first, and then we constructed and built a kind of place that would be welcoming. When security were asked to okay it, they were horrified. There were no fences around. There was no protection. What, the judges, people can walk past 24/7, day and night, past this building. And we held firm, and we quoted Jane Jacobs, a noted American, I think from New York, town planner, saying it's the eyes of the people provide the best protection and security. And we've maintained that to this day. Why did it mean so much to me? It was much more than just having been in the anti-apartheid struggle, much more than just getting a wonderful new constitution, getting rid of the laws. It was the intensity of what race had been in our society. I still recall the very last case I had. I was in practice as an advocate, you would call it an attorney in Cape Town. The very last case involved a family that had been reclassified from white to coloured in terms of the 4 racial groups in South Africa. Every human being in the country had to have a race identification. And I was looking forward with loathing and horror to the experience of having to argue in an appeal against that reclassification. It wasn't simply a question of destroying your identity and all the privileges that went in so many different ways, the assumptions made for being white. They'd have to leave their home and move to an area reserved for coloured people, happened to be grossly inferior, manifestly so. The children would have to be taken from the school they were in. They couldn't go to the beaches anymore. They couldn't go to the cinemas anymore. That reclassification literally redefined who they were, what they could do, what expectations they could have. Even jobs that were reserved for whites only were now excluded to them. And I couldn't say, I object to the very idea that people don't want to be removed from the category of white to coloured. The people I'm working with in the underground and the resistance were mainly black South Africans. Why should you object to being reclassified? And yet how can you say that to somebody whose whole life has been turned inside out? But the part that horrified me the most was at one stage in the evidence it showed the magistrate who was making the classification asked the 4 children to come forward. And he said, "Show me your hands." And they showed their hands, and he made a determination based on the colour of the skin on their hands. And I'm an advocate. How can I go to court and start dealing with evidence like that with the calmness, the detachment that you need if you want to win a case for your client? Well, that dilemma was resolved. I was thrown into prison. I wasn't able to carry on with that case. But even in prison, this is so weird. It's so South African. Whiteness followed me even into prison. And I remember at one stage I'm locked up. Now I'm in solitary confinement. I'm the enemy of the state. And one of the white warders says to one of the black warders, his subordinate, "Fetch some water for the boss." I'm a traitor. I'm the enemy of the state, but I'm the boss. And years later, when I'm blown up, so many of our people were blown up, but my white body counted for so much in the world that we're in. So much of the news media, the imagination of the TV and so on could identify with me and carry my story. But I can't say, don't tell my story, because it's perpetuating a form of privileged information. So I see myself as a kind of a diplomat, telling the story on behalf of all our people who were blown up and tortured and mutilated in one way and another, to try and get them to get the world to support our struggle. But it's a dilemma. There's a price even to telling your story, because it's being picked up as a white person, the story of liberation. So to be working in a place and a space where I'm a human being, I'm a person, I'm a believer in justice. We are working together as part of that team. And it wasn't just the space, and it wasn't just the architecture. You will know what the atmosphere was like. And it became so much more pronounced when we began to have a representativity, at least in terms of race, in the court, and the leadership, and the debates, and the discussion, and Lega Moseneki, and Pius Langa, and Yvonne Mogoro having absolutely equal voice, sometimes stronger voice than Albie Sachs and Kate O'Regan. And it was the clerks, and the interaction between the clerks and the secretaries. There was just that little wonderful world to work in. I'm going to mention another woman's name, Sharon McPherson. Anybody in this room know Sharon? Well, she knows a lot of you. African-American law clerk. And I'm preparing a judgment. It was actually a concurring judgment dealing with the criminalization of sodomy, which we declared to be unconstitutional. And I've actually quoted Du Bois in terms of the being visible and invisible. So already at the beginning of the 20th century is writing stuff so relevant to us in South Africa then. But I mentioned that you can't say the theme involved here is simply one of privacy, which some people argued. Of course it's privacy. Or equality, of course it's equality. Or it's dignity. It's all of them. And each reinforces the other. And Sharon put up a hand and said, critical race feminism, UCLA, Kimberly Crenshaw, an article. And she was the first law clerk I allowed to write anything in one of my judgments. She got a whole paragraph, a whole footnote to herself, quoting Kimberly, dealing with critical race feminism and introducing the term intersectionality. And good ideas are good ideas, and they transplant themselves and they show different flowers, if you like, in different terrain, different nutrition. That theme of intersectionality was used later on when it came to the question of partners of same-sex partners of South Africans who were foreigners coming in and claiming that they were being denied equality under our law because they were not married. They didn't have the same status as heterosexual wives and husbands had. And the argument of the state was, but there's nothing stopping them from getting married. The law doesn't say you can't get married. The only problem is you have to marry somebody of the opposite sex. And the only way we could overcome that conundrum was through intersectionality. It was a combination of your human dignity, your right to marry, to choose your spouse, coupled with no discrimination on grounds of sexual orientation. And the term intersectionality became a term used by our court. We used it again later on when it came to the multiple forms in which African women, widows, were disadvantaged. As widows, like so many widows, as women, like so many women, but also as African women, in terms of the patriarchal rules that had been applied by the courts. And so we used the theme of intersectionality there. Let me conclude by bringing in Cheryl. So everybody here started with saying something about Cheryl. I'm going to end with it. It brings a kind of closure to the presentation. I think we first met in 1991, thereabouts, when a team of American lawyers visited us at the University of the Western Cape. We had a wonderful, sparky interaction. And ideas that later on became the ideas in our Constitution were ideas that now we're being celebrating today, 20 years later. But we didn't have a text, you didn't have a text at that stage. But there's a kind of a textual bond, if you like, through emotion, through understanding, that's often deeper than the literal word. But it didn't stop there. 1992, the Constitutional Committee of the ANC was invited to visit the US of A. And the highlight of our trip was going to Chicago. And it was a wonderful time to be in Chicago, because it was shortly after Harold Washington had been the mayor. And he said something there, and I'm sure we met up at that stage. Cheryl, I think, had quite a prominent position in Chicago in terms of developing ideas and so on at that stage. And he said something that really became foundational to what we did in South Africa. And he was quoted as saying, "No one, whoever you are in Chicago, will escape my fairness." Now that's so powerful. It's stronger than Kathy Freeman. It's transcendent. It's not being nice to the oppressor. It's, in a sense, transcending the very notion of oppression. And that's what we were aiming to achieve in South Africa through our constitutional endeavor. And the feeling of the inputs, the vigor, the vitality of people like Cheryl and Kimberly and others, the team, And I wish there was a little more emphasis on Cheryl as a team worker, Cheryl as part of an institution builder. This is the way it came through to us. So it's really to say thank you, Cheryl. Thank you to the UCLA, critical race studies, critical feminist studies, critical race feminism in particular, and thank you to the organizers of this conference. It's been terrific. One's heart needs a lift without leaving your brain behind. And I think that's what we've achieved. Thank you.
So we now have about 15 minutes for questions. Yes.
So I'm fascinated by how the law shapes our sense of identity, what it tells us about who we are, where our relationship to others and to the state is. And I'm also curious about how the law is or is not shaping identity differently abroad. So this is informed by Professor Trumay's remarks, but anyone, I'd love to hear from all panelists. You know, what happened to Mrs. Berman afterwards, right? Did the court's decision both play this redistributive function, but also re-educate her or others about how this has to happen going forward? I'm curious, and I'm curious as to how that is or isn't happening other places. I'm hopeful, but we didn't do what we wanted to do for individuals.
So I don't know her and can't really speak for what's in her soul, but it happened a month ago, and all the newspaper reports express her disappointment that she wasn't able to, she actually didn't want to be put into the position of lieutenant anymore, she just wanted the money. But what's interesting when you're reading the judgment and actually the pleadings is that she concedes that affirmative action is worthwhile, and those ends are ends that the society should pursue. What she's contesting is the way the policy was applied with respect to her. And actually what had happened is that she ended up being promoted within the South African Police Service anyway to a different position, even though she had been denied those two. So it's an interesting thing. She's not the kind of plaintiff you read about in U.S. Supreme Court cases, to say the very least. And so there is that.
Somebody mentioned how, almost crying, was it you, Cheryl? Reading how the American Supreme Court had struck down affirmative action. We had one case where that cropped up, and I almost cried when I read Thurgood Marshall's dissent in the Richmond set-aside case, and where he said that sometimes 100 years of history is worth 10,000 pages of literature. And he said, here's Richmond, which was the heart of the Southern Secession Civil War, center of slavery, and a largely white council is taking some steps, some moves towards bringing about some readjustment that would be fair. And now this court, by narrow majority, is striking that down and saying that race discrimination is the same. If it's a discrimination that leads to Jim Crow and using race to segregate people in schools or even slavery, and discrimination that's to deal with the relics of the past. He said, how can you say it's the same thing? It's taking account of race in the one case to oppress, in the other case to free people. And it was very, very painful reading that. And to the extent that our court repudiates that kind of thinking completely, it's helping to establish a new public morality. The Barnard case was difficult for a number of reasons, but it was unanimous. There are 3 white men, as it happens, on the court, 2 African women, and the rest are African men. And they were unanimous, but it wasn't plain sailing. One of the issues was, as a woman, she'd suffered systemic disadvantage in the past. And that's one of the issues that's being dealt with, and it's not straightforward. Some people say white women shouldn't be in the game at all, because they're white, they benefit from so much. And I personally disagree with that. I think it will be very unfortunate if one racializes the gender issue completely. But you've got to take account of that. There have also been questions that didn't crop up in that case, but in terms of disadvantaged black people, and were black Africans more disadvantaged than people classified as colored, than Indian people, and that's also being manipulated quite a lot. And the court has to develop a language that's sensitive to all these different issues, but based on a principled outcome. And one reason I love Cheryl's work so much is that it introduces the importance of storytelling as part and parcel of constitutive of legal imagination and ultimately legal reasoning. And in that sense, the experiential dimension becomes extremely important, but we are telling stories. And when we tell a story about Mrs. Grootboom, when we tell the story like the bit you quoted from, we use the word oppression. I don't know when last an American court used the word oppression. You use it in relation to North Korea and China and elsewhere, but I'm not sure it's been used in relation to, so even the vocabulary can be very, very telling and meaningful. But we have to work through it and agree ourselves. The law doesn't itself convey a status, bring it about, but it does an enormous amount to deal not simply with claims that people have and that they can enforce through the court orders, but through what does it mean to be a South African, to be a human being in the country. The essence, if you base everything on dignity and equality as the foundation, rather than freedom in the pure sense of you can get on and do your best for yourself, pure freedom in a very unequal society is going to benefit the people in charge because they've got everything. And now freedom is used to resist any transformation and change. So we place dignity at the core, human dignity at the core. Equality is our first. Like your First Amendment came first. For historical reasons here, for us equality came first. And the focus on equality, I think, has been extremely significant in our country, but it hasn't brought about the massive transformations that are still required. And that has to be done in conjunction with the court and the law, but not simply through the court and the law.
Yes.
Yes, my question was for Tanya. It's been on my mind since you spoke, and it's kind of two-part, and I'll try not to stray too far. But the first question was, you were talking a lot about the ways in Brazil and the ways in which through law whiteness as property was enacted and stuff. And it made me think about, I believe it was in '96 when Gary Webb put out his controversial article in San Jose about U.S. intelligence working to traffic narcotics into the ghetto in order to fund a war against the Contras, or the war with the Contras in Nicaragua against the democratically elected government at the time, the height of the Cold War. And that a lot of things he talked about also was the OSS bringing over Nazi war criminals in order to extract Russian intelligence and propping those ex-Nazi war leaders up as dictators in places like Argentina. So my first question was kind of, in your experience and in looking at the law, in which ways U.S. imperialism or things, the Cold War, for example, would play into that sort of process. Second question was, in the people that you meet, well, just in general, the idea of Africans in Central and South America. What about the claims and a lot of evidence that points to Africans in Americas before Columbus, as in Ivan Sertima and stuff? Thank you.
I'll start with your second question first. I want to be honest that the research that I have engaged in thus far was inspired to make a very particular intervention. And so I don't address this latter issue, not to say it's not important, but it wasn't one I was angry about. And I like to be very honest, so I think Cheryl appreciates that about me. And I get fired up. To write is a long and lonely process. All of you in this room know that. And in order to sustain you through the boring parts of it, right, I find that I have to be passionate about it. And sometimes my passion comes from anger. And so what I was angry about was the constant denial of the existence of racism in Latin America with the strategic positioning of comparisons to the United States. So that, we're not racist like the United States. And so that's why I didn't deal with these other issues that are just as important, but didn't focus my fire in that same way. And then with regards to your first question regarding U.S. imperialism, what's really quite striking for me about that issue as well, and it particularly plays into the contemporary scene, right? I regaled you with a lot of historical stuff to sort of model myself on the Whiteness is Property historical intervention. But when you look at the contemporary period, what is very striking is the ways in which some of the elite resistance to Afro-descended social justice movements in Latin America is positioned as you're trying to import U.S. ideas about race that are ill-fitting to our more harmonious and racially mixed and more nuanced and fluid context. And so that's you being imperialist. And there are actual articles and lots of news stories that take that elite perspective and try to bring into this idea of all of Latin America as subaltern, and so there can be no subalterns within the subaltern. And those are very tricky politics to work through. But that's the way in which I see it in the Latin American context. Thank you for asking these questions.
So I'm going to take two questions now, and I'm also going to add my own. But first, Professor Gomez in the back, and then here.
Okay, can everybody hear me from here?
I think you need to come up so they can
You want me to
record
come
it.
to the mic? Okay, if Cheryl's telling me to come to the mic,
Yeah.
I will come to the mic. So I'm actually, well, I want to thank all of the panelists for your presentations. It was really a terrific panel. I'm tired, so I'm just going to offer two comments. One is there was a really interesting, well, I think the themes running from our morning panel today and until now are really interesting and having to do with what you raised most directly in your talk about the potential and limits of law. And so you and Aileen were more on the side of, estrangement from law, as you said, but Tendai and Albie were more on the positive side. And I think that's something we're going to get to talk about tomorrow some more, too, when we think about praxis. But I thought it was very clearly presented here. And then, Tanya, I have a comment about your work, which is which I admire greatly, but there's a recent study that came out in, I think Demography was the journal last week or the week before, and it was very, I think, important because we don't get too many studies where people are looking in smart ways at the United States in comparison to Latin American countries. So this article looks at 19 countries, including the U.S. and Mexico, and then 17 other countries from Latin America and the Caribbean, and was testing three different models of race. One looking at categorical race, another looking at interviewer, and this is a large N data set. The other one looking at interviewer rated skin color, right? So the interviewer had a skin color
This is
panel.
all the Eriteles work?
No.
Okay.
It had a panel, and there were like 10 shades of, and then the third model was the combination of the two. And what was interesting about this article is that it showed in the vast majority of countries that it was the combination of the two models that was actually the most explanatory of income inequality. And so I think it's a pretty interesting study in terms of beginning to kind of do some of the work you're doing, which is to say, it's, of course, ridiculous to say there's no racism here and there's racism here, but really to look at it in a more complex way. So I just wanted to mention that to people. Thank you.
Go ahead.
Thank you very much for this panel. It was absolutely incredible, and I feel so privileged to have been able to hear this and see this. So my question is for any of the panelists who feel interested enough to answer it. It was fascinating to me to see these sort of transnational threads that come out and how law is made and how norms are made. So this was in the South African context a bit, and then in Professor Hernandez's comments just now. And we know that in the States, our courts, and in particular the Supreme Court, doesn't often turn to foreign jurisprudence or foreign scholarship to draw from and to say, oh, let's look at other situations that have dealt with this or have handled this in some way. And I was hoping that if people found it interesting, they might comment on what the view is of foreign jurisprudence or foreign ideas in terms of, not just for the law, but in terms of the reasoning and the methods of analysis and the social norms that people write about elsewhere. And if the places that you study and where you live do look to foreign jurisprudence, and how is that held?
And I'm just going to throw in one, I guess maybe more comment in the spirit of what Professor Gomez said than question. But I invite anyone to address it. And I was most struck in the Australian and Israeli-Palestinian context, but actually across all of the presentations, the focus has been on how domestic law has operated in each of these contexts. But all of these contexts are drawn together by international law, and specifically the law of sovereignty, the law of colonialism, the imperial nature of international law, from the slave trade, which was mediated by international law, to the doctrine of terra nullius, which explains the experiences of all indigenous populations that have come into contact with white European society, which was the only society endowed with sovereignty, and then their colonial settler populations, to the projection today of international law, whether into the disenfranchisement of Palestinian populations under so-called laws of occupation, or in the deployment of international law to denounce racial dismantlement such that Robert Mugabe can only be known as a villain internationally. And so I wonder, it's a substratum of everything that was said, and yet it wasn't surfaced as international law as a vehicle of the projection, production, entrenchment of racialized property regimes that began in one place and came to dominate the entire international conception, really, of how political sovereignty operates, and that then becomes the backdrop for each of these domestic legal regimes, and also, in part, the explanation for the incredible resonances amongst them. So I just thought I would add that as a comment for anyone to engage who might wish to.
Could I tag one more thing on to that, Asla? Not that that's not enough, but I am from DePaul, and I think this moment, I want to thank George and others for talking about the oppression that dares not speak its name in the United States and providing us with PEP, which is a great acronym. But in light of what's currently going on, and from DePaul having seen what happened to Norman Finkelstein, and currently in Illinois with Stephen Salida, I wonder whether you think that we are witnessing something to the effect of whiteness as civility.
When did it ever stop being?
So, engage.
Yeah, so first of all, not in a published opinion, but in her confirmation hearings, Elena Kagan stated that the judicial figure she most admired was Aaron Barak, the former Chief Justice of the Israeli Supreme Court. And there are in other realms, again, not in the U.S. Supreme Court, but in the U.S. Justice Department's white paper on drone killings, there is direct resort to and citation of Israeli law. It is, of course, not the form of resort to foreign jurisprudence that one would necessarily hope to see, but there is that influence and exchange that's actually, I think, quite significant and quite troubling, and something that somebody should be writing about. With respect to international law and the law of occupation and the adequacy and inadequacy of that to offer protection to Palestinians, there's actually a very lively debate that's going on right now among scholars and activists and lawyers and others who are concerned with this over the shortcomings of international law, and particularly international humanitarian law, of which the law of occupation is a branch. We are, the person who really sort of kicked off this debate in a very public way was John Dugard. I would imagine, Albie, you probably know John. John, former South African jurist, now a professor at Leiden University in the Netherlands, and the former special rapporteur for the occupied territories for Palestine before Richard Falk. And he suggested at the end of his tenure that the law of occupation had really come to its useful end, and instead we needed to be thinking about the introduction of discourse concerning the law of colonialism and the law of apartheid. So there, as I said, I think this was the sort of the first step in the initiation of a debate, and there have been subsequent developments, and I think that there is movement in this direction. So we could all be sort of guilty or vulnerable to the criticism that to a hammer everything looks like a nail. So lawyers always want to come up with some kind of legal argument, some legal approach that can be useful, but I guess for people in the community that I've been describing, we're not stopping simply because the laws that are most prevalent and the most familiar are unsatisfactory. So we believe that it is possible to push the boundaries of international law. And the first step in doing so really is, through legal scholarship and this sort of discussion and discourse. So that's actually going on now.
Can I just support that and maybe take it a step further? When we were discussing a Bill of Rights for democratic South Africa while we were in exile, some people said it will be a Bill of Whites. The whole idea of the Bill of Rights is to prevent the new democratic South Africa from bringing about any change. It will simply freeze the status quo. And I was asked by Oliver Tambo, leader of the ANC, to make out the case for the Bill of Rights, because he was the one who really saw that as the answer to claims of white protection and privilege and consociationism and so on. And the approach that we developed was, why hand over the theme of a Bill of Rights to a conservative pro-property definition of it? Can't we make it into an emancipatory document? Can't we infuse it with a different dynamic and look at social and economic rights, environmental rights, and gender rights, and so on? And then we enter into the fray rather than abandon the fray. And I would say the same, and in support of what we've just heard about international law. It's true, international law was created by the big, powerful, colonizing, first mercantile nations, then afterwards industrial nations of the world. But people have resisted that. International law supported ultimately the fight for national independence, and the Universal Declaration of Human Rights was a response to the racist ideology of Nazism. Even the American Constitution produced, when Cheryl came, somebody from your group said, we, the people, declare, we, the white people declare, we, the white slave-owning people declare, we, the white slave-owning patriarchal male people declare. And we could have turned our backs completely on the notion of constitutionalism, but then the answer was to say, no, now we must enter into the debate, we must infuse it with our values, and we mustn't give up on that. And more, I'm finding, I spent the first part of my life looking for certainty, the second part of my life is spent managing contradictions, but to be aware of the contradictions and see the contradictions in the international law, which can and has justified oppression and war, but also international law can and has justified independence and emancipation. We use international law quite a lot, not so much the treaties, but we look to decisions of foreign courts when we started off, because we didn't have precedent in South Africa. We had to create precedent, we couldn't use precedent. And we felt partly South Africa was a creation of international law. We got huge support from all over the world, support in this country from people who believed in certain universal values, and that should be reflected in our interpretation of the Constitution. And that's drawing on the best that international law offers, rather than becoming totally cynical about international law and handing it over to the people who want to block progress.
Just a few words about the international law and also and the use of U.S. law in Latin American courts. What's interesting is that because Latin America is a civil law context, there's this notion that no, it's very formalistic. They won't look at cases, let alone cases from a foreign jurisdiction. And there's actually a great deal of variation on that. But there is much more of openness to a U.S. case law and international law with regards to issues of race. And we saw it in Brazil most recently with regards to looking at the importance of international law and anti-discrimination and U.S. anti-discrimination law, the good stuff, in validating affirmative action in the public universities. Although when I say variation, then there's also just the outright complete disregard for international law that we saw in the Dominican Republic in their stripping of citizenship of people of Haitian descent many generations back. It's a travesty and very racially motivated. But one place I want to conclude with regards to these issues of nuances as an addendum to Laura's commentary about the color and the use of the color palette. Quite familiar with that work, and what I have found very interesting is that in Latin America, in its strategic comparisons to the United States, the notion is that, we have a fluidity and an appreciation of color in Latin America that doesn't exist in the U.S., and hence, again, we have moral superiority because we see color variation and respond to it, unlike the United States. And what's so fascinating about that is that that's an invention of what the U.S. is. And what the U.S.'s own experience and experiences continue to be with regards to color in relation to race. And by that, all I'm doing is referencing all the social science that points to the ways in which it's not just race identification, but the hue of your skin that has an impact on your socioeconomic opportunities in the United States, also combined with your gender, right? So that we find that dark-skinned black men, right, are the ones who have the most difficulty locating job positions, even when you control for educational status. Right? So what's so fascinating is that it's not just that color also matters in Latin America, but it matters in the United States too, but that's something that we don't talk about. And it's racialized. So it's not just color neutrally, but a very particular notion about a hierarchy within color.
Yeah. In the Australian context, the Mabo decision did rely on international law, right? But the subsequent cases after that reduced it fundamentally to legislative findings. So there was an exclusion of any engagement with international law or just, precedents that occurred in Canada or the USA. So the law cherry picks, the courts cherry pick about when they want to use it. And in the Australian context, unless an international covenant is ratified in domestic law, the international law fundamentally doesn't have any impact. That's the dominant view of the courts. But I want to raise an issue about the fact that there are the problem that we have as Indigenous peoples within Australia is that our laws don't fit within patriarchal white sovereignty's idea of law. So the way and the kind of rights that we get in land are fundamentally funneled through rights, whereas our laws are not, they're not funneled through rights. So the law, in one sense, has constructed an idea of what it thinks our sovereignty was constituted through, that is, their idea of rights. But in actual fact, that's not how we see ourselves. Like our relationship to country is an ontological relationship to country, born of ancestral beings, etc. We have rights not in the same way. It's more about responsibility and obligation. So the kind of ways in which Indigenous people's sovereignties can't be configured in any other way except the way that law can configure it, and that's through rights. So for me, rights is problematic because rights becomes a mechanism for subordination. Yeah, because by making our sovereignty in this box of rights, it actually negates our sovereignty because it constructs something that is not of us. Yeah. So maybe I'm just a cynic. By the way, I'm not a lawyer. Don't hold that against me. My husband's a lawyer. My daughter's a lawyer. 2's company, 3's a crowd. But yeah, so I think that I look forward to the day when the idea, and let's be honest here, we all share the law of empire, which was international to begin with, right? You know, the reason that we have such synergies in terms of what happened is because of the common colonizer. And I would even go so far as to say what's happening in Palestine, right? The British were very good at it. You know, and if we look at the law, even the way the law is constructed, the similarities are there. So we share this lovely legacy, you know, from Britain. And, you know, in Australia we can't send them home.
Tendai.
So two very quick comments. I think in terms of international law's role in fostering racial oppression, I think one of the areas where this is happening in a way that isn't discussed very much is in the area of international criminal law and international criminal justice, where you currently have an international criminal court that's entire docket is black Africans, and it's actually hard to imagine there ever being a different demographic. Oh, Gaddafi, but it's true. Well, he's African, at least. You know, so he gets in. It's hard to imagine that demographic will ever be different, and I think that's a case of structural discrimination that is racial. And then just going back to your question, Professor James, about the different ways that race shapes racial identities, I just remembered an example that I think is very fascinating. It's in the area of immigration. So in the U.S., xenophobic discrimination really is directed towards non-whites in a context where you have the majority for now, I guess, is whites. In South Africa, it's the reverse. You have xenophobic discrimination against blacks, even though the majority is black, and that is very much tied to the history of various laws, and the South African historians that have really tracked the way that even under apartheid, you know, migrant laborers were the ones, black migrant laborers were the ones who were viewed as competition, and even now as xenophobic discrimination plays out, the way that identity is structured, influenced by law, has resulted in a different sense of who the foreigner is or who the outsider is. So that's really interesting.
George.
I just wanted to say a word in response to the question about whiteness as civility, and thanks for that question. There has always been pressure within American academic institutions exerted against people who criticize Israel or express support for Palestinian rights. Beginning about 10 years ago, the form of that pressure took a particular turn in the argument that was made in lawsuits and in complaints to the EOC that criticism of Israel created a hostile environment on campuses for Jewish students, and that's kind of the genesis of this notion of you know, sort of civility, and that I think is you know, it is linked to that. Now, I should mention as well. A few years ago, I organized a conference at UC Hastings called "Litigating Palestine: Can Courts Advance Palestinian Rights?" And I came under attack. The school came under attack. Funders were threatening to withdraw funding from the school. And I want to publicly thank Noah Zatz and other members of this faculty, 25 of whom signed a public letter in support spontaneously, not at my request. So. One of the other reasons I'm always glad to come to UCLA is that solidarity that was offered to me a few years ago. The positive thing is that Stephen Salaita, who's the one under the gun currently in the University of Illinois case, has received a great deal of support. And we can't know the ultimate outcome of that case, but the response of many academics in the United States to his, you know, to the withdrawal of the offer to him has been encouraging, and shows me that there is positive movement despite you know, pretty tough odds.
Well, on that happy note, unfortunately, we do have to conclude. Please join me in thanking the panel. Yes. Yes. Unenviable and failed, I might add.
It's really fun to be able to
it's going to be interesting to see.
Great.
Oh, you were?
Yeah, no, but you first one you did.
Have a program will be great.
Yeah, I wanted to
Brazilian.